Welcome, my dear students. This is your teacher, Dr. Usama Kashwa, and this is we'll talk today about the business law. We're working on the business law today, and this is a new topic, a new chapter regarding the business law. So I wish everybody will get what we want to talk about in this lecture, and I will repeat back whenever there is a chance, if there is something is missing or something need to be more in detail, we will talk about it again or we'll repeat it. Elements of contract. This is one of the most important parts of any business law in the transactions, in all the transactions. So first of all, we'll see what do we mean by a contract. What is the contract? What is the contract and the contents of a contract? A contract is an agreement between two or more parties that is enforced by the law. It's enforced by the law. The law enforces it. It's an agreement between two parties. We have someone and someone, they agreed on the sale of this particular thing in that particular time with a particular place. They agreed, okay, I am the seller, you are the buyer, and this is the material or the stuff which we are agreed that you buy it from me. So there is, both of us are having a willing to do this. Both of us have obligations. Both of us have obligations. My obligation or my responsibility as a seller is to provide it to you in a good condition. Your responsibility as a buyer is to pay to me in return. No one tilt our hands and tell us that we must do this. No, it's left totally free for our willing, voluntary, without any kind of duress or any kind of stress or any kind of force. Our willings went to agree on the same thing. As long as there's a contract, then it will be enforceable. Enforceable means that it is compliancing for both the parties. Both the parties, the seller and the buyer, has to do what came in this contract, are responsible about the acts which came in this contract. Okay, a contract is an agreement between two or more parties that is enforceable by law. In order for a contract to be considered valid, valid means effectable, you can trust it, you can depend on it, is not refused, is not rejected by courts. Valid means a good contract. There must be offer and acceptance. Okay, then we talked before about the offer and the offer and the offerer and the offeree, and we said the difference between them. And there must be offer, and there is acceptance for this offer. The offer here, hey, I want to sell this pen for you. This is an offer. The acceptance, and I agreed to buy this pen from the buyer side. I agreed to buy this pen. Consideration. Consideration for the thing which is the stuff. Capacity, consent, and lawful purpose. So then when we are doing a contract, it must be legal. But I can do a contract in sex traffic, or I can do a contract in selling cocaine. I can do a contract in, it must be legally. It must be legal, permitted, a permitted work, so that it will be lawful. Okay, let us see. Offer, acceptance, and consideration. In every valid contract, offer, acceptance, and consideration are vital aspects. They must be there. Those three must be there. The offer, the acceptance, and the consideration. Okay. First, an offer is made that contains all of the important and relevant terms of the contract. So the offer, including everything is made that contains all of the important and relevant terms of the contract. So I will sell for you this pen. It will come to you within 2 days. You will receive it within 2 days. It's with $10 price. I can give you a discount of $2, so I will sell it for you $8 if you will buy tomorrow. So all this is called offer. Okay, I will deliver it at your home. or I will deliver it in my shop and you come and receive it and take it with your own transportation to your destination. So all these are offer. An offer is made that contains all of the important and relevant terms of a contract. Second, another party agrees to or accepts the offer. There must be someone who will accept this offer. There must be someone who will accept it. Without the acceptance, then there is no contract. If there is offer only from one side, where the contract then? There must be acceptance from the other party. Third, after the offer is accepted, something of value, an item or service, is exchanged between the parties. We always say goods or services. We don't say goods only, items only. We said goods or services. And let me tell you, remind you what the difference between the goods and the services. Goods are tangible, you can touch it. This is goods, the pen is goods. But services are intangible. The meaning of intangible, that you cannot touch it. Exactly like what I'm doing now. What I'm doing now with the services, you cannot touch it. You cannot hold it in your hand. For that reason, it's intangible. So goods are tangible, but services are intangible. This is the first thing. Or visible and invisible, that's fine. The second thing in between them is that the goods can be stored because it's tangible, you can touch it, so you can store it. You can put this stuff on a shelf. You can store it on a shelf. This pen, you can put it on a shelf. But the service which I'm doing now, I cannot put it on a shelf. I cannot put it on a shelf. I cannot store it. So services cannot be stored. Services cannot be stored, but goods can be stored. The third thing is that the goods is not related to its provider. The goods is not related to its provider. As example, if you need to drink, to buy a bottle of water, a water bottle, and you need to drink, you're very thirsty. The first shop will face you on the way, on your road. You will stop and go there and buy the bottle of water. You don't care about the seller, how he is, silly, funny, has sense of humor or whatever. You don't care about the characteristics of the seller or the nature of the seller in the goods. But in the services, you care too much about the service provider. So as example, if I am doing now this, what I'm doing is teaching. And actually when I'm teaching this, you ask, if you go to a doctor, before you go to him, you ask about this doctor. Is he clever, skillful person? Is he treating the people well? People who go to him never complain. So you see that the goods and the services are not the same. So goods can be stored, services cannot be stored. Goods tangible, you can touch it, but services you cannot touch it. And finally, goods are not related to its provider. You will buy water from anywhere, you will buy match from anywhere, you will buy cigarettes from anywhere, but services are related to its provider because the services, you ask about the service provider before you go to him. So that's why it's related to its provider. Those are the three things. So we said now there must be offer, there must be acceptance, and there must be consideration. The consideration is what you are going to exchange, what will happen between you as seller and he as a buyer. What is the article? What is the article of both of you are considering, or what is the article which both of you are putting concern, or what's the article which both of you care about? That is the goods or the services. We call it consideration. So the goods and services, we call it consideration. The offer is accepted, something of value, an item or service. So this consideration means goes to the word goods or services. Okay, we'll stop here now and say a question. Insert, we will insert here, we will insert new slide and say here, as example, what are, okay, I have to, Sorry about that. We'll say what are a question. What are the terms? We can say the terms. What are the terms? Or what are the considerations of, or what are the terms of a contract? What are the terms? The terms of contract to be valid. To be valid. Without this, your contract will never be valid. Without this, your contract will never be valid. To be valid. So here we will stop for about 5 minutes to take the answers of my dear students. Please send your answers on the chat box. Send your answers on the chat box. So what are the terms which we need for to be valid, for the contract to be valid? We said the offer, the acceptance, and the consideration. So those are the 3 points, 3 main points. But we still also, we have the consent and we have the lawful capacity. So here we go. I will actually delete this slide. That slide. Then I will go also. So also we'll have like capacity and consent and the lawful purpose. And those are the 3 things. Please add them also to your answer. So the capacity, in every valid contract, both parties must have the ability or capacity to understand the terms. So I must not be insane or a small kid who did not understand what are the meaning of the terms which come in this contract. No, I have to be very aware of each article. Each word is written in that contract. I have to be very careful about this. And the nature of the contract as well. And also the nature of the contract. Each party involved in the contract must also freely consent or agree. Otherwise, why I'm coming? I'm coming to say, no, I will not buy this pen. You are offering me this pen. Then acceptance means willing. The acceptance included in the consent. You agree on buying this pen. So this is consent from you that you agree on buying this pen. Finally, every contract that is negotiated in Canada must have lawful purposes. Lawful purposes must be admitted legally. Must be admitted legally. So it must be right in the right time. It must be right. It must not breaching human rights. It must not be breaching the normal and the rules. It must be in accordance with what should be and what should not be. So lawful purpose objective, in other words, no contract can violate any law. So as example, if you want to make a contract about sex traffic, children traffic, no. If you want to make a contract about trading in the cocaine or morphine, no. If you want to make a contract regarding selling subway station to someone, no, because subway station and the subways are owned to the government or the municipal of Ontario. So these are all not legal work. So those were the components of the contract or terms that should be there in the contract to be valid. To be valid. Those 6 points which we talk about, these 6 points which I talk about. So please, I will stop here 5 minutes. Send your answers to the chat box. Answers on chat box. Here on the chat box, still, because there are some students, they have their own D2L, and other students, they don't have the D2L or the portal. The portal is not ready. Please go and answer today on the chat box only. We'll answer today these questions on the chat box. Shall stay here about 5 minutes, then I will move forward to another point within 5 minutes. Thank you. Please go on answering this question. What are the terms of contract to be valid? This is our first question today. This is our first question today, and the answer should be there on the chat box. Thank you so much. The answer on the chat box. We'll be back after within 5 minutes to take another point. To take another point within 5 minutes, we'll move on to another point. And the answer, like I showed you, the answer is here. The answer is here on the slides, where you can see the slides here. The 6 points: the offer, the accept, the consideration, the capacity, the consent, and the lawful purpose. Those are the 6 points of a valid contract, or how should be a contract for the contract to be valid. Thank you so much. We'll be back within 5 minutes to continue our work. Please work on the question. The question is here. We have 5 minutes to end this mission before we move on to the other point. Again, the question: what are the terms of contract to be valid? What are the terms of contract to be valid? Thank you. Cool, perfect. So we'll go now to the second part now of our lecture. We'll go to the second part now. Okay, we finished the conditions of the contract. Now we'll move into the types of contracts. What are the types of contracts and how we can signalize between each type and the other type of contracts. The types of contracts in Canada here are an express contract. It is a legal agreement in which the terms are transparent and known to all the parties involved. Like as example, the mortgage with the banks. Everybody know about the mortgage with the banks. It's very clear. Everybody know about it. Everybody know all the details of these kinds of contracts. There is also, we have an express contract. We have an implied contract. An implied contract is a contract that is implied. Implied means it is inferred by the parties' conduct. As example, the restaurant. It is implied that after eating dinner, the customer will pay. So it's something like logically. It's not that you have to write it or say it in a word, because it's already known for everybody. You go for a restaurant to eat, you know that after you eat, you will pay. So this is a contract, but it's implied contract. Okay. Most contracts are under seal. A formal written contract, the under seal is a formal written contract that is signed, witnessed, and marked with a seal. Like exactly the contracts for selling a house, for selling a farm, it must be sealed and must be witnessed by people who would say that they saw you signing as a buyer, and they saw the seller and the buyer signing. So those, they usually be two witnesses, and sometimes one in some special cases, but mostly in two witnesses. And it's stamped also. The contract itself, there is a stamp to stamp the contract. Okay, a simple contract, after this, a simple contract is a contract that is not under seal. So that one is a very simple verbal, written or implied, but without seal. So we have seal contracts, under seal contract, and we have simple contract without seal. So we have the two contracts, under seal and with a seal contract, both of them. We have both of them. So now this was the types of contracts. This was the types of contracts, and this was the second part. We talked about the types of contracts. Now we will talk about the elements of contracts. Elements. What are the elements that should be in a contract? The elements of the contract is an offer and the acceptance. Acceptance, like we said before, the offer and the acceptance. The party who initiates or makes the offer is known as the offerer or offerer. The party to whom the offer is made is known as the offeree. So the seller is the offerer. The prospective seller is the offerer. And the prospective buyer is the offeree. Okay. In a valid contract offers, there must be serious intent on the part of the offerer. In valid contract offers, there must be serious intent. Intent means I have the intent to sell to you. I mean it. I do this purposely, not all of a sudden or by accidental while I'm walking in the way. No, it is intended and I mean it to do this offer. I am the seller. I intended to do this offer and to sell this thing for you, and you will accept or no. But till the moment I have the intent inside me to do this. The offer must also contain definite terms. Also, the offer, it should contain definite terms or details. Some terms are clearly defined while others are implied, means logically included. So some of them are known, some of them are clear, written, and other conditions are implied, means logically you can understand it logically. You don't need to write it. It's hidden, it's not seen, but it's okay, it's working. When a company or business encourage the purchase of a product or service through advertising, this is invitation to treat. Okay. But before this, we would say the offer must also contain definite terms or details. Some terms are clearly defined while others are implied. We said this before. So this is a point. When a company or a business encourages the purchase of a product, they encourage the purchase of product or services through advertising. This is an invitation to treat. Okay, again, when a company or a business encourages the purchase of a product or service through advertising. So now, while I do advertising, I encourage you to buy. This is called invitation to treat. A contract occurs when a product or services has actually been purchased. But the advertise, no. In the advertise, you are not, you didn't buy it. Simply, you did not buy it. So it is not a contract. There is no contract because you did not buy. There is no purchase process. The purchase process is not there. You just made an advertise and the people know that you have something to sell, but no one bought yet. When I buy and purchase, then this is a contract. There will be a contract after the transaction, when the transaction is occurred. Okay. Now we'll go to the communicating and terminating. Parts of an offer includes communicating the proposed contracts to the offeree. That's what we were saying. We had offerer, we had offeree. We had offerer and we had offeree. And there is something in between them. They have to exchange, which is the consideration, which we call it the consideration. So part of an offer includes communicating the proposed contract to offeree. Common methods include communicating in person. So I can send it to, I come to you and say, hello, I have a house to sell. Would you want to buy it or no? I would say, would you like to buy it or no? So this is the first point. I will do it in person. I will do it in person. Or common methods include communicating in person or by mail or by the mail, courier, fax, and email. Those are the ways. I will send you through the email that I have a house and I want to sell it. Or by the fax, or by the courier. I will send you up pictures for the house and I will send it by the courier. Or by the mail, regular mail. So all these are ways to send you, to communicate you as offeree. I'm offerer, I'm the one who's having the thing which I want to sell, and you are offeree, which will accept or not accept later on. Okay. So this was the first point. Then after that, we'll talk about communication is not successful unless it is received by the offeree. Communication always is the transformation or the shift of the information from the seller to the buyer, or from a person to another, from the sender to the receiver. The sender is the offerer. The receiver is the offeree. Okay. If the offeree did not receive the message, then there is no communication, because to have a communication, there must be a message, and the message should be received by the receiver. The message which is sent by the sender should be received by the receiver. Okay, the receiver or the offeree did not receive it, did not receive the message, then there is no communication, because this is a part of the communication. It didn't happen, then there is no communication. So if it is cut in the way, you send me that you need to sell your house, I need to sell my house, and I send it in the post, but for a reason, the message did not go to the offeree, then in that case, there is no communication, because the offeree did not know anything. The receiver did not receive anything from you. Should receive, but he didn't. Okay, then there is no communication in that case. Okay, communication is not successful unless it is received by the offeree. An offer can be terminated or canceled for various reasons. So any offer is done by the seller or the prospective seller to the prospective buyer, the offerer. The offer can be canceled or void, or as it didn't happen in some cases. What are the cases? For various reasons, a lapse occurs when an offer is not accepted within a period of time and the offer ends. So if I tell you, I will sell to you this house with 20%, this is my offer. I will sell for you this house with 20% discount if you buy it within 10 days. Then 10 days passed and I didn't hear from you. Then this is a lapse. This is a lapse. Again, a lapse occurs when an offer is not accepted within a period of time and the offer ends. So I didn't hear from you for the 10 days. That means you didn't agree. You didn't accept the 20% discount. Then it's a lapse. An offer may also be revoked or canceled by the offerer before it can be accepted. Or the offerer or the seller, the prospective seller, might change his mind and he doesn't want to sell. He regret back. He regret back in his offer. This is, we call it revoked. Okay, I regret. I said I want to sell, that I don't want to sell. I'm not interested in selling anymore. I'm not interested in selling anymore. So in this case, or cancel, I will cancel it. I don't want to do any offers again now. So offers again, I don't want to do any offers. An offer may also be revoked or canceled by the offerer before it can be accepted. Now we will come to the acceptance part. But before we come to the acceptance part on the slide 8, let us go back to see some of the points which said now we have acceptance and consideration, consent and lawful purpose, types of. We will ask a question now. What are the types of contracts? The second question today is, what are the types of contracts? What are the types of contracts? The types of contracts. What are the types of contracts? What are the types of contracts? And here we go back, copy. I will get this up, 1 sec. And I will put here down the answer. What are the types of contracts? And also you will answer on the chat box. You will answer on the chat box. Whoever did not have D2L, please answer it on the chat box. So what are the types of contracts? What are the types of contracts? This is our second question today. This is question number 1. This is question number 2. So we are here now. What are the types of contracts? This is the question now, which we are answering. So please go for this question and answer it. What are the types of contracts? What are the types of contracts? We'll have here 5 minutes. We'll have here 5 minutes for answering this question. And the answer is there, the implied contracts and which we saw here, implied contract, express contract, simple contract. I will leave the page open under seal or sealed contracts, seal or under seal contracts. So I will leave this page open for you guys to get the answer of this question. What are the types of contracts? Here it is. What are the types of contracts? It's 1-4, 1-10. We'll move to another idea. I will give 6 minutes in this part. Then we'll move to a new idea. Thank you so much. I'm just reminding you back, the question is what are the types of contracts? We still have one more minute here before we move into the next question or the next part. Now we'll move into the next part. This one already. We took the 6 minutes for this question. Types of contracts. They are express contract, implied contract, under seal contract, and simple contract. The 4 types of contracts which we talk about. We'll go now to, we talk also about the communicating and debts and the lapse and offer and revoked. Acceptance. One of the most important parts in the contract is the acceptance part. And the acceptance means that the offeree will say, yes, I want to buy. I want to buy. Yes, I want to buy. This is the offeree's rule. He will say, I want to buy. So similarly, the offeree has a responsibility to clearly communicate its acceptance of the proposed agreement. He must show the acceptance. The offeree means the prospective buyer. The offeree is the prospective buyer. He must show his own intent to accept or accept, I'm accepting. Offer may be accepted using the same methods of communication, like the email, courier. So I can send, if I receive it by email, I can accept it by email as it or by the courier. An acceptance must occur before a specified time limit on the offer expires. So if the seller said this offer will be expired within 1 week, and the offeree did not make a decision within this 1 week, he made his decision after 1 week, like after 9 days, 10 days, then in that case, it won't work. It won't work. So the acceptance must occur before a specified time limit on the offer expire. The expiration of the offer, before the offer is expired, the offeree may decide to make a counter offer. So what do we mean by this? The offeree may decide to make a counter offer, which is a new offer or amendment to the original offer. So he might adjust. He might say, no, not 20%. Why don't you give me 30%? Why it is not, instead of 20%, I need discount 30%. It's talking to the buyer, to the seller. The offeree want amendments or change a part of the contract or change part of the offer, add to the offer or increase from the offer or whatever, any adjustment for the original offer. So offeree in that case is making counter offer. When he adjusts in the original offer, he will or do some adjustment or some suggestions or whatever, or see that there must be points should be added to this offer. In all these cases, we call this counter offer. Change, modified, or any modification to the original offer. We call it counter offer. Any counter offer ends the original offer. Any counter offer ends the original offer. Of course, it's very shown up that it will be ending the original one because it will change it. The original one will be not more there, and the new one with the amendments of the offeree will be there. Consideration. What do we mean by the consideration? We talk about the consideration. We said this is the article, goods or services, the thing which our own willing, the buyers and the sellers willing, tended to work on, the main object of the exchange, which is goods or services. Okay, after an offer is accepted, something of the value must be exchanged between the parties who are involved in the contract. Because any contract must include something that will be exchanged between the seller and the buyer. There must be something that will be exchanged between the seller and the buyer. Otherwise, why the contract? Why it is there? It's only because of this purpose. Okay. The actual value of amount exchanged between the two parties or consideration does not matter. No matter for this to the courts. So if you are selling the comp or selling a diamond of 15 million, the court do not care about it, about its value. The court care about what is the matter or the stuff of consideration between them, regardless of its value. Okay, the actual value or amount exchanged between the two parties, consideration does not matter to the court. How much I paid for this, how much I paid for this. This is your consent went to this as buyer and seller, but the court got no hand in this. A contract can appear to clearly favor one side over the other. So what we want to say here is that the consideration, something I will sell for you, and you have like this as example, and you will pay for me for this item. Okay. A court simply want to see that there is some degree of exchange or consideration. So we can say that the consideration is the article of the exchange, the article that we will practice on the exchange between the seller and the buyer, between the seller and the buyer. A court simply wants to see that there is some degree of exchange or consideration involved in this contract. Perfect. That's very nice. So what about the capacity? What do we mean by capacity? And what is the meaning of the capacity and how the capacity help us? A contract will only be considered valid in court if the offerer and the offeree had the capacity to understand what they were agreeing to. The capacity means the ability to understand. You won't get insane or mad person or a small kid who does not understand anything under 16 years old or under 18 years old, and you will tell him sign on a contract because he does not know and not aware of the article or not aware of what's going on. In that case, the capacity is the ability to comprehend and understand and know each point in the contract. A contract will only be considered valid if in court if the offerer and offeree had the capacity to understand what they were agreeing to. Anyone with developmental disability. So if I have a child with a disability or impaired judgment, or who is under the age of majority in Canada, 18 or 19 years old, does not have the capacity to enter into a valid contract. Okay, this is a very important point. So any person under 18 years old or is having mentally disorder or is having a problem, impaired judgment, in that case, no way. He is not accepted to enter in a contract or to sign for a contract. Because he's not fully comprehending for what's going on. How he will sign for something he didn't understand it. How he will sign for something that he couldn't understand what does it mean. Okay, a minor may enter into a valid contract if it is considered necessary to ensure his or her health and welfare. As example, employment contract. If a contract is not considered to be in the minor's best interest, it is declared void. Those are the points which we have to care about in the previous page. All I want you to know is that it is void, V-O-I-D. It is a void contract. If a person under 18 years old sign it, or if a person with mental disabilities sign it as well, it's void in that case, because he cannot comprehend and understand what are the articles or what are the written in this contract. He cannot understand the terms of the contract. How about the consent? Our willing, me as a buyer and you as a seller, our willing, our acceptance, our both of our willing, voluntary, without you didn't press me, you didn't stress upon me, or you didn't tilt my hand and tell me you must sign. No, I did this fully with my fully desire and fully volunteer. I did this totally with total volunteer, without any press, without any duress, without any compliance, without any use of force to force me to do this contract. Consent in general, each party is a contract must freely agree. Look at the sentence, freely, freely, F-R-E-E-L-Y, freely agree or consent. So it's free, freely agree. No any pressure that you sign for something. No tort, no kind of pain, no kind of stress or causing pain to let you by force sign. Nothing. You did this all with fully desire 100%. Or consent to the contract. An offeree must completely understand the terms of the contract. Of course, if he didn't understand it, well, then it will be void. Or he shouldn't sign before he understands, because once he signed, he is obligated to do all his responsibilities in this contract. The contract is enforceable. The contract is enforceable. The meaning of the word enforceable, that once we signed on it, we have to do it exactly. We have to do or act accordingly to what is there of the conditions or required from both the parties of the contract. Everyone will do his responsibilities towards the points he should do. You, I am the seller, I have to deliver the goods which we both agreed on to you as a buyer. With the time, with the quality agreed, in the time agreed upon between me and you, and in the place which is written in the contract. The buyer should pay for this article in also the time and the place and what the conditions which is written in the contract. Each one will do his job or will show the responsibility and will conduct the responsibility of each single word came in this contract. An offeree must completely understand the terms of the contract. There are some situations that may prevent consent from occurring, as example. Like what? Like misrepresentation. I didn't understand very well. So I need, before I do the consent, to understand. Mistakes. If there are mistakes written, undue influence or duress, all this will affect the consent, so it will make the contract void. All this will affect the consent, which is a term of the contract, so the contract will be void in that case. So another point, we call it mispresentation. Another point, we will call it mispresentation. So what do we mean by the mispresentation? What is meant by the word mispresentation? Mispresentation, as you see, is a false statement about a material fact. False, something is false in the contract. We wrote a false sentence that is so important that it causes the other person to enter a contract. So it might be harmful, and it will make the consent impossible. Let me tell you as example. Let me tell you an example. If I say in the contract between me and you that you work for me $300 hours per month, it's impossible because you cannot do 300 hours per month as work. So the conditions of the term itself. So even writing consent here, consent or not, I didn't understand it very well. I didn't understand the sentence. There are mistakes. There are misrepresentation. Innocent misrepresentation. occurs. This occurs when a person incorrectly believes something to be true. As example, the sales clerk repeats and manufactures false claim about a product. The fraudulent misrepresentation occurs when one party tries to deceive the other. So if I want to cheat you, I will hide some facts. I will try to change the truth. That's all can kind of flies so that I can proceed in the selling process. I hide facts on the buyer. I hide information on the buyer. So that will lead into a big problem with the buyer, because it is decisive. It is kind of like cheating the buyer. Okay, and it's done intended. I mean, purposely. It is done purposely from the seller to put fake information. He's trying by any way to proceed in the contract process by letting the buyer sign, and the buyer might sign on something wrong. That's why. Okay. Both types of misrepresentation allow a buyer or offeree to back out of the contract. So the misrepresentation is a reason for the contract to be void. Simply is a reason for the contract to be void. If you take it to the court, then the court would say this contract is not conductible, is not conductible. You cannot proceed on. You cannot. It cannot work because there is misrepresentation in this contract. Because there is misrepresentation in this contract. I will stop here for another question now. And the question is, what do we mean by the misrepresentation? What do we mean? The third question today. 3. Discuss misrepresentation in contracts. Discuss misrepresentation in or misrepresentations, because we have more than one type in contracts. Discuss misrepresentation in contracts. And here we go. We'll have here also. So this is question 3. Discuss misrepresentation. Also, the answer should be on the chat box. The answer should be on the chat box. The answer should be on the chat box for those people who do not have D12. And for today, it's okay on the chat box. Discuss misrepresentation in contracts. And this was the question. And actually, the answer, like you see here, here is a page of the answer. We'll stay here around 5 minutes to gather information. If you can go to Google to see for examples of the misrepresentation, that should be fine. You can go to Google and check out for some meanings of the misrepresentation. That will be fine. We'll give here around 5 minutes. We'll be back around 1:35, like after 5 minutes, sorry. After 5 minutes, we will be back to work on another part. Thank you. The question again, the question, discuss misrepresentation in contracts. Discuss misrepresentation in contracts. This is the question. Thank you. Cool, we'll go now to the next point after this. Okay, we'll go to our next point. The mistakes. What about the mistakes? What about the mistakes in a contract? Mistakes. Certain types of mistakes can make a contract enforceable by law, means void. Enforceable here means that the contract will be void, like it's not there anymore. So certain types of mistakes can make a contract enforceable by law, like a common mistake occurs. What are the types of mistakes which will cancel the contract, which will make the contract as it is not there? What are those types of mistakes? The first one is called common mistake. Common mistake. So when did the common mistake happen? Occurs when an error is made by both parties in the contract. So both the parties do mistakes. This we call it common mistake. This will make the contract void. Remember, this will make the contract void. Common mistakes like what? E.g., an agreement is made by purchase a product that is out of stock. So you want to buy a product which is out of stock. So it's not there. You know it's not there, and I know it's not there. So both of us know that it is not there. So in that case, the contract will be void. This is a common mistake. This is the first kind, a common mistake. Occur when an error is made by both parties. Both the parties shared in this error. They did this error together, both of them. So that's the first point. That is out of stock. Unilateral mistake. The second type, the first type was common mistake. The second time, unilateral mistake, is when one party to the contract made a mistake and the other party knew of it, but did not try to correct it. We call it unilateral mistake. One did a mistake and the others know about this mistake, but he didn't correct it. He just discarded it without correcting it. We call it unilateral mistake. Okay, as example, buying a product to use for a purpose it was not intended for. The clerk is aware that the product will not work for that purpose, but does not say anything. So the clerk here knows that the reason you bought this product, it won't work with you, but he made pretend that he does not know. He didn't say anything. Okay, this is called unilateral mistake. Again, when one party to the contract made a mistake and the other party knew of it, know this mistake, but did not try to correct this mistake. He didn't tell him, hey, no. The product which you want to buy is not for the purpose which you need. You can take this one instead. He didn't say like this. He just passed it over and that's it. Discard it. This is unilateral mistake. The third kind of mistake is a clerical mistake. A clerical mistake. It is an error caused by a clerk, okay, or store employee. Clerical mistakes often involves numbers such as incorrect prices. If you told me this is for $2, but when we came to the contract, you wrote it 15. You wrote a price of another product, not the item which I want. The item's number is 111, you wrote it 121, and 121 was with another price different than the item number 111. This is another mistake. So all these mistakes can lead to make the contract void. All these mistakes can lead to make it a void contract, means not working, not acceptable. If you go to the court, they would say this is canceled. Don't work on this contract. Okay, So those are the mistakes: common mistake, unilateral mistake, clerical mistake. Let us go also to one of the reasons for void, void or the cancellation of a contract, and as the cases that this contract will not be enforceable for both the parties, the seller and the buyer. What are those? Undue influence or duress. So we know what is the meaning of undue influence and what is the meaning of duress. When one party applies pressure on the other, when I apply pressures on other people, as example, aggressive salesperson, to form a contract, this is undue influence. So you just buy it, it's okay, it's a good one, buy it. So it is like I'm doing stress on you to buy it, by like too much stress. When one party applies pressure by repeating, you buy it, you just buy it, take it, it's very good, like that way. And I'm saying, hey, take this, okay. On the other, I'm practicing pressure. As example, an aggressive salesperson to form a contract. This is undue influence. Or you must buy it. Hey, you must buy this. This kind of aggressive behavior from the salesperson. This is also can make the contract void. Void means as it is not there, as it should be cancelled. Okay. Any contract that is formed with undue influence lacks proper consent and will be declared void. This is the article or the act saying any contract that is formed with undue influence lack proper consent. So I don't have a consent to agree on it, but I went down pressure. In that case, it is void. This contract will be void in that case. In that case, this contract will be void. Duress is similar to undue influence, the same. Duress have the same meaning when one party uses threats, such as blackmails. Okay, you will sign or I will show these pictures to blah, blah, blah. You will sign or I will do like this. I'm threatening you to sign for the contract. I'm threatening you here, okay? I'm blackmailing you to sign. When use blackmail or violence, or I tilt by force, I forced you to sign. I put a gun or a pistol in front of your head and told you sign on this paper now. Sign on this contract. So all this will make the contract void. It is not acceptable. And if it goes to court, the courts will say it's not working. No one has any obligations regarding it. And stop working on it. Okay. There is a similar to undue influence when one party use threats such as blackmail or violence to intimidate the other party into forming a contract. That agreement would also be cancelled. So this also will be cancelled. The last thing for the contract, or was one of the most important points also for the contract, which in the absence of this point will make the contract void. Void means not valid, is the lawful purposes. It must be not breaching the law. It must be not breaching the norms and the system of the society. It must be in accordance with the values of the society. Okay. No contract can violate any provision of the criminal code in Canada, as well as we'll come to see what do we mean by the word criminal code in Canada, as well as any provincial law or municipal bylaw. So any breach, a contract that breach the the criminal code or the federal law or any of the provincial law or any of municipal, like Toronto's municipal bylaw, any contract that breach any of those is illegal and it is a void contract. We use the word void to say that it's a canceled contract. It is deactivated contract. You cannot work with this. And if this contract is breaching one of the main, the federal or provincial or municipal laws, that means it is not acceptable and it won't work. This contract will not work. Each contract must have a lawful objective or purpose. Lawful means goes legally. Legally, you cannot say I will make a contract with you for a children traffic. No. Or for hiring children, you will bring for me children to work. No, because this is not lawful objective, illegal objective. Certain contracts require special rules or restrictions, as well as government intervention, like betting, gaming, and gambling. So in all the cases, this contract, it must be, like I told you, it must be in its own. It respects the lawful environment or the legal environment. So we'll go for discharging a contract. And what do we mean by discharging a contract? Okay, discharging a contract. Once contract has been successfully agreed upon, there can be several different ways to discharge it or end it. Discharging a contract means ending this contract. Discharging a contract means ending this contract. Okay. The performance, the mutual agreement, the impossibility of performance, and the breach of the contract. Any point of this will end the contract. Like we said, I think we said this before now when we are talking, but with different expressions. So any of those points will discharge the contract. The performance, the mutual agreement, the impossibility of the performance, very hard to do what came in the contract, and breach of contracts also. Let us see. Okay. We'll go first for the performance and agreement. The performance and agreement. The mostly common way to discharge a contract is through the performance. Simply put, one or both parties fulfill their parts of the contracts. Contract may also be discharged if the parties involved mutually agree to end it. So the end of any contract can be done with the willing of the parties of the contract, the two parties of the contract. If their willing came to that they must end the contract, then it is discharged. Or yeah, so it will be discharged. If the willing is saying that's more than enough, we don't want to do contract anymore, we have to stop this contract, but both of them together. In that case, they can discharge. The contract means end this contract. Discharge means end working with this contract. A contract may also be discharged if the parties involved mutually agree, like we said. Various factors may exist for the parties to end a contract through mutual agreement. For example, they may agree to terminate the current contract in favor of a newer one. So we might finish it now, the old contract, because to update and do a new contract, including some extra points or whatever. The current contract in favor of a newer one with different or additional terms. With additional terms. Okay. The second reason for discharging is the impossibility So what do we mean by impossibility? What do we mean by the word impossibility? Impossibility or frustration of a contract occurs when the term of a contract becomes impossible to fulfill. I cannot do this. It's hard. It's impossible. We can do what came in the contract. I cannot work for you 300 hours per month. I can do this. I cannot do a work for 300 hours per month. This is impossible. Okay. Over the years, Canadian courts have excused one or both parties from contracts if it can be proven that the certain circumstances prevent them from performing their part of the agreement for any reason. For any reason. I can't do my part of the contract for impossible reasons, which is out of my hand. Then in this case, we call it impossibility, and this impossibility will discharge the contract or end that contract. For example, a music promoter may have to cancel or reschedule a concert if it is rained out. So if there is rain, yeah, and I have to do open air, the party in an open air. Then how I will do this while it's raining? In that reason, I have the right to cancel and discharge this contract. Other points is the breach of contracts. Like you see here, the breach of contract. So what about the breach of contract? Let us see what do we mean by the breach of contract. Failing to perform an obligation owner to another party is a breach of contract. Failing to perform an obligation owed to another party. So we are two parties in the contract. I fail to do my part towards you. As example, I bought from you this pen. You as a seller delivered the pen, but I didn't pay for it. This is a breach of contract. This is a breach of contract. So failing to perform an obligation owed to another party is a breach of contract. It is the direct opposite of performance, because actually the contract for both the people to conduct an action, but I didn't conduct anything. I didn't pay the money. I didn't do what I have to do. In that case, this is a breach of contract. The failure to perform a specific and essential term of a contract is called a breach of condition or breach of warranty. They call it also, when I don't do my part, my obligation, I don't do it in the contract, we say breach of warranty. Breach of warranty. Again, I didn't do my part in the contract. We call this breach of warranty. Any breach allows the other party to cancel or end the contract. So this will allow any party to end the contract. Okay. If one party has fulfilled most of these terms, this may be logged as substantial performance. If one party has fulfilled most of the terms, this case we say substantial performance. He did what he has to do, or almost done for what he has to do. This we call it substantial performance. Okay. And the party may avoid being found in breach. So I did my part. I did my part. Why I will be in breach then? There will be no breaching. The breaching of the contract is for the person who did not do his own part, who did not do his responsibilities about the contract, which is mentioned in the contract. Okay. Remedies. Like the remedies is like the doctor, exactly when you go to the doctor for treatment, how we will cure the position of the breaching the contract, how we will deal with it, how we will deal with this situation of breaching a contract. If we breach a contract, if there is a breach for a contract occurs, the following remedies are available. Damages. We have to compensate the damages for the injured party. Like as example, if there is something in the contract that you build this area, but you break a wall here, so you have to pay or return the wall the way it was. So that's how I fix or compensate the damages. This is a way for curing the contract, for making the contract valid, not void. Okay. Specific performance, the court may order a party to fulfill the terms of a contract. So you didn't do the conditions of the terms of the contract, you didn't do it. So the court will enforce you to do it, will let you do it. You will do this in the court by force. You will do this. Injunction. Injunction means the opposite of performance. It is not doing anything. Injunction. One party is ordered not to fulfill the terms of a contract. So one party is ordered not to fulfill the terms of a contract. So I will tell you, don't do it. Because if you do it, there might be damage on the other party. Privity of contract. In lawsuit, the plaintiff proves that it has a contractual relationship with the defendant. The last point is the rescission. The court may order the contract to be cancelled. So the court will see no way, then this contract should be cancelled. We will stop here for this lecture, and we will start our next lecture from slide 21. Thank you so much. Have a very good day. Bye-bye, everyone.